Start at 9:30. So we're going to do as much as we can to be on time. Welcome to the Senate Energy, Utilities, and Communications Committee. Today we're having an oversight hearing on the California Public Utilities Commission and the Office of Ratepayer Advocates. This is the annual update to the legislature. In particular, it's the annual update to the Senate. We will begin. I imagine we'll have members coming in just a sec. During this hearing, we intend to hear from the CPUC President Michael Picker, as well as the CPUC Director Tim Sullivan, and other CPUC representatives and staff. This hearing will allow the Commission to account for all of its transactions and proceedings of the preceding year, so everything last year up until now. And it is also intended to describe its scheduled rate-making proceedings and other decisions that may be considered by the Commission during the coming calendar year. So anything in the past and prospectively looking. More importantly, I do believe that the hearing is an opportunity for a conversation between the top leadership of the CPUC and members of the Senate. I do want to encourage an ongoing conversation. So there might be a little bit of interrupting going on, and I'll try to manage that as much as possible. But I did want to have a discourse today so we can get a lot of information out to the public. Much has happened since the committee heard from the CPUC during its 2015 annual report. A lot of things have happened both on the legislative side and on the administrative side. Legislatively, SB 350 by the Senate and Senator Pro Tem De Leon took a leadership role on that. That bill is now law. The legislation of 350 most notably requires investor-owned utilities to procure at least 50% of their electricity from renewable sources by 2050 and calls for a doubling of the energy efficiency savings in electricity and natural gas uses by 2030. Needless to say, implementation of this historic legislation is already making great demands on the CPUC and will continue to do so, we imagine, in the upcoming years. And of course, SB 350 is not the only demand made by the CPUC and the legislature. Also last year, hi, how are you? The governor vetoed several bills passed unanimously by the legislature that sought to reform operations and the culture of the CPUC and more appropriately known as the ex parte communication rules that we were seeking to implement. Despite those vetoes, the Commission itself has continued a series of transformative measures, so there have been administrative gains in that area. Those measures include the adoption of a code of conduct for commissioners, establishing an internal audit unit, and clarification of the Commission's own ex parte rules, a subject of some of the bills vetoed by the governor. So that's nice to hear that the PUC is responding to some of the legislature's wishes. I want to begin by commending President Picker, his fellow commissioners, and the Commission's administrative leadership for those ongoing efforts. And I want to assure you, members of the public, and of course the leaders, that you do have my support in these measures. The Commission has also refocused its efforts on safety. As you can imagine, safety and the CPUC's role in ensuring the safe operation of the state's utility infrastructure is very much in the minds of members of the legislature. Over the past few years, the state has experienced catastrophic failures, most notably the natural gas pipeline explosion in San Bruno, and more recently, the massive leak of natural gas from the Aliso Canyon storage facility. Such events have cost Californians their lives and their dollars, and stand as reminders of the tremendous responsibility the CPUC has in regulating the state's utilities. As I mentioned, I expect this hearing to serve as a conversation between the CPUC and committee members. With such a conversation in mind, I encourage members to ask questions freely as the course of the meeting extends throughout the time here. Regarding today's order of business, we will hear from staff of the Office Ratepayer Advocate. I understand the governor has appointed a new director of the Office of Ratepayer Advocate, Ms. Elizabeth Eccles. We would be happy to have heard from Director Eccles today. However, I've been told she will not start as director of the ORA for several weeks. Being mindful of that, I do plan to make time to hear from Director Eccles during one of our regular scheduled bill hearings in the future. We will work out a time that works for her and members of the public so we can hear about their important business activities. I think in the meantime, it's important for me to hear from the staff of ORA to keep in with the responsibilities of this committee and to have a good understanding of the role of ORA and the relationship with the CPUC as approved by the people of California. With that, I welcome the staff of the ORA, if you would please come forward and introduce yourselves. Do we have anybody just simply, just to make a brief introduction?
Good morning, Chair Hueso, committee members. My name is Linda Sarazawa, and I am the interim director of the Office of Ratepayer Advocates. I've been the interim director since January, following the former interim director who retired in December. And as you mentioned, the governor has appointed a new director who will start at the end of this month, Elizabeth Eccles, and she looks forward to appearing before the committee to share, to introduce herself and share her vision for ORA.
Okay.
We have given you a presentation which highlights the 2015 activities of ORA. It's actually not that sheet, it's a thicker packet. Well, actually, I was going to say, instead of going through that packet page, that's the annual report, but there's another presentation. And I was going to say, instead of going through that presentation page by page, in the interest of time, I thought I would just tell you a bit about who ORA is. That's it, yeah. And instead of going through that, I thought I'd tell you a little bit more about who ORA is, what we do, and in doing that, highlight some of the activities that we've done in 2015. So if that's okay with you, I'll start from that perspective. So ORA is an independent advocate group within the California Public Utilities Commission. And we're responsible for representing ratepayers of communications, telecommunications, water, electric, and natural gas services. We were established by the state in statute in 1996, which means that this year actually marks our 20th anniversary. Okay. Our specific mandate is to advocate for the lowest rate consistent with safe and reliable service. We have a director who reports directly to the governor and is responsible for establishing and maintaining a budget separate from the commissions. We have talented and skilled staff who feel very passionately about ORA's mission. And I really can't tell you enough about how hard they work to protect the ratepayers day in and day out. So in 2015, we saved the ratepayers in terms of avoided costs and rate reductions over $5 billion. And we did that through participating in over 190 proceedings before the commission, filing over 600 legal pleadings, participating in numerous evidentiary hearings, and filing legal briefs. We also attended town hall meetings, public meetings, informal workshops. And the general rate case proceedings are primarily our vehicle for achieving this cost savings. So general rate cases are proceedings where the utilities propose how much money they'll need in the next 3-year cycle. So they are a forward-looking proceeding, looking at, again, how much the utilities will need for capital investments, for operation and maintenance, and for customer service. And it is a soup to nuts review of their business. So just to give you an example of what we do in a general rate case and how we achieve those cost savings, I'll start with Southern California Edison. They filed their general rate case application, and in it, they proposed $18 million to fund a long-term incentive program, which is basically stock options for their executives. We took a deep dive into their plan and determined that the proposal really didn't directly benefit ratepayers. It benefited the company, but it didn't really flow to the ratepayers. So we recommended that the commission disallow that $18 million. And based on our analysis and what we presented in testimony, the commission agreed with us. Another example is where we're looking at the Great Oaks Water general rate case. Great Oaks Water is a small water company, and they filed for a 8% increase in revenues over the previous period. That's almost $2 million in revenue increase. This is a small water company, so that's a huge increase for their customers. Our staff team took a deep dive, looked at the application. They did extensive discovery, which is basically issuing data requests, looked at the information provided by the utilities, did site visits, and interviewed personnel of the utility. All this to determine that the company really didn't deserve an increase. It actually should have got a revenue decrease. So in our testimony, we recommended that they cut their revenues by 13% over the last period. It's a significant difference in positions, obviously. Fortunately, we were able to settle with the company, and we presented that settlement just last month. And in the settlement, we propose an 8% revenue or 7% revenue decrease. So the company did agree to decrease their revenues, and that decrease is very close to what we litigated. So in this way, this is how we do these deep dives in terms of what the utilities business operations are and what they need. We have auditors that look at the records of the utilities to determine if there are any irregularities in how they're recording their costs. We have engineers who look at their capital projects as well as their operations and maintenance projects. We have policy analysts who look at the utilities' cost forecasts and will develop their own forecasts if necessary. All this goes into developing what we call testimony, and which is basically written arguments to present our positions before a judge and the commission. And then our staff prepared to testify before a judge and be cross-examined by the utilities and other parties' attorneys. And then after that, we prepare legal arguments that are filed in legal briefs, and all that goes into the record of the proceeding. And I say all this because now it's time to look at the sheet of paper. So what's listed here are all the important steps, and this is, I want to emphasize, a very simplified list of what goes on in a general rate case. All the necessary steps that occur in a general rate case that ORA actively participates in. And on the back, just for a little interest, are actual boxes of a picture of actual boxes of information that we have in ORA. This is thousands of pieces of paper that we get and pour over. It takes months to do. and we analyze the utilities data this way. In addition to our analytic work, we also take a look at complaints lodged by consumers with the utilities and with the commission. We work with legislative offices in terms of constituents' concerns, and we also work with local government. So, as I said, all this goes onto the record of the proceeding and allows the commission to consider options to what the utilities have proposed. And while there are other consumer advocate groups participating in the commission's proceedings, they generally represent large customers. So we're talking about large industrial and commercial customers. ORA focuses its advocacy on residential and small business customers. And I do have to say that we take that job very seriously. We represent the people who can't do all these steps. They can't prepare testimony. They can't testify. They're busy living their daily lives, and we are there to represent them. In a lot of the proceedings before the commission, we are the only advocate to represent consumers. So with that, I'll pause and see if you have any specific questions of us, or Matthew may have additional information to provide.
We'll probably just interrupt you if you do. So if you, did you want to add anything else? Okay, wonderful. Anyone from the committee?
Go ahead. Mr. Chairman. Yes, I have a question. So every rate increase goes through this process that goes to the PUC, is that correct?
Yes.
So like, I have a Kerman Telephone, they've been requesting to have a rate increase for several years, and they went through that process. I don't know if you're aware of that particular telephone company, but was that an 18-month process as well?
I understand it's gone beyond 18 months.
Well, no. Well, the initial, when you first started looking at it, it's gone a lot longer than 18 months. And is it unusual when the ratepayer advocates and the utility company come together and agree on a settlement and then it to be rejected by the PUC? Is that fairly common?
I have to say, in my experience, it's not fairly common, no.
It happened in this case, though, right? The Kerman Telephone case. I think the settlement was rejected, so that's unusual.
I would consider that unusual, yes.
All right, thank you.
If I could follow up on Senator Cannella, looking back, do you think that was the right decision of the PUC to not accept that decision? And that was back at the end of 2012 when that occurred.
You know, I'm going to have to defer to Matthew Marcus, who is more familiar with this case.
Okay. So typically, as you said, we work with the utilities and we enter into settlement, and that's part of our everyday business. And one point I want to make on at the outset or onset is that we actively review the small telephone company GRCs for prudency and for reasonableness. And we do this to meet our statutory mandate, and we do this with, to adhere to and consistent with the deadlines set by the PUC. And so every deadline set by the PUC, we were responsive and we helped build a very robust record before the PUC. And so we did what we could to provide the decision maker the information they need to make a well-informed decision.
Do you think the PUC has the appropriate controls to prevent delays like this in the future? I mean, this has really gone on way too long, and do you feel that they're, I mean, especially in light of the 18 months that you showed us in this, I mean, do you think they're doing it right, or we will find ourselves in the same position again?
Right. I could speak on behalf of ORA, and I can tell you that ORA did its due diligence. We reviewed the data, the company data. We did this for prudency and for reasonableness, and we tried to build a very robust record before the PUC.
I'm saying, do you think the PUC has in place
I think
controls to prevent that from happening again, from what you've observed? Because this is obviously either an anomaly or it's accepted behavior.
Well, and last year, the commission had revised the general rate case plan for the telecommunications companies and actually adopted a proposal that ORA put forward to streamline the process to something like determining the company's cost of capital instead of having the companies have to present their cost of capital applications or proposals separately. We propose that they do that all together, again, to streamline the process. So I do think the commission, given this revised general rate case plan, is on the right track.
Okay, that's good to hear. A couple of other questions, if I could, Mr. Chair. You have a new energy safety and infrastructure branch within the ORA. You've heard that in the Aliso Canyon discussions that Southern California Gas identified a negative well integrity trend in its most recent rate case. And I mean, this happened when they filed the rate case. So they identified a potential problem that they were having. What do you envision the response of ORA's Energy Safety and Infrastructure branch when they see something like this in a rate case? What's your kind of opinion of it, and how do you act on that? Do you see that, because there's obviously this conflict that we're seeing now between, low rates and then safe service and providing safety, and I know that's really the balance, and I just want to make sure that you're addressing those issues in that new branch to make sure that when something like that is identified, what do you do with that information?
I actually don't see a conflict between low rates and at least in terms of our mission, which
I
is
think you're alone in that, then, if that's the case.
Our mission is to advocate for low rates consistent with safe and reliable service. So we're very clear about safety being first. In terms of how we're ramping up to address safety in rate making, the commission, and acknowledging that there needed to be more of risk assessment, safety risk assessment related to rate making, its rate making processes, approved a proposal that ORA, working with TURN, put forward last year. It was adopted last year. And what this proposal does is it creates what's called a risk assessment and mitigation phase. This is a phase that actually happens before a general rate case. So it takes the consideration of safety risk out of the arena of litigating costs and requires the utility to provide information about all its safety risks associated with its whole business and how they propose to mitigate those safety risks. That information is provided to the commission and to parties before a general rate case starts. And what that does is it prioritizes safety and helps us come out with the best safety outcomes. So again, it's an information gathering process. The Commission's Safety and Enforcement Division takes the lead in analyzing the data and comes out with a public report, which all parties, the whole public can comment on. So it gets the utilities' plans are vetted. And I think the great thing about this is that it takes what was once an internal process, internal to the utilities, and makes it transparent to the public and allows parties to vet the information and ask questions of the utilities in terms of the safety risks they see. So we are actively participating in how that phase will be implemented. We're doing that right now. And actually, we understand that the risk assessment and mitigation phase, which is called RAMP, is going to start at the end of this year.
So you feel that risk assessment and mitigation plan or mapping would have determined, and you would have been able to identify when they indicate a negative well integrity trend, that you would have followed that through that risk assessment to determine that there are resources that they needed to make whatever necessary repairs or accommodations so that trend is stopped. Obviously, before, we're a little late in this one, I know, but there may be others.
I believe that this phase is designed to capture that kind of risk, yes. And it's certainly designed to take the information that we get, given this unfortunate experience, and feed that back into our analysis going forward. So with every experience we have with safety, that should flow back into this phase. And it's an iterative process, so it happens every time before there's a general rate case. And that will inform the consideration of costs later on down the road when the utilities file their general rate case proposals.
And I guess it's the urgency in some cases, and I know we've talked with the president on this and Mr. Sullivan on the issues of, when does that flag an urgent or required action, especially no one can tell, obviously, if it's going to happen tomorrow or 10 years from now. But obviously, in this particular case, immediacy would have been more important than not. One other question, if I could, and this is and the other part with in terms of the negative well integrity trend, it wouldn't have captured the Aliso Canyon problem, basically, I think, because it doesn't identify hazards, and that's the difference. I don't think what you're talking about will identify a particular hazard. It's more of a trend, so it wouldn't have occurred there. But why did ORA agree with the utilities to postpone? I know there's that case for an extra year, the energy utilities cost of capital to determine, really their return on equity. 10.4%, as we know, is still one of the highest in the country compared with other states. And so what is the thinking related to that?
The utilities, actually, before the decrease in the cost of capital, actually had much higher cost of capitals. And so the decrease that was approved by the commission a few years ago was a significant one. We felt that given the market conditions and in terms of California utilities, which are very different from the rest of the Western region in terms of their complexity, in terms of the largeness of their service territories, basically, that it's difficult to compare California utilities to the Western region per se. So we felt it was reasonable to wait another year. We didn't think that there would be, there's a trigger mechanism in the current cost of capital proceedings so that if the market changes to a certain degree, then it would trigger an up or down movement in the cost of capital. So to protect against that and to protect ratepayers, we had the utilities agree not to freeze that trigger device. So the cost of capital won't go up. And we just didn't, based on our market analysis, see that another cost of capital proceeding would necessarily benefit the ratepayers.
Okay, good. Thank you. Thank you, Mr. Chair.
Thank you. We're going to move forward now. Thank you very much. Thank you for being here. We're going to move forward with CPUC's presentation. I'll ask President Michael Picker to come forward and with your team and begin when you're ready. Thank you.